so much for coming. We are so excited today to present Republic Title.
Thank you.
And
Thank you.
they're here to talk about the contract. I just wanted to know that I have a passion about our contracts, even though there are lots of problems, but it's so important. And I just heard it from Tina. And this is exactly the reason why we brought Republic Title today to talk about contract, because they are confusing. It's causing so many issues, like different brokers and different teams and different interpretations. And that's exactly why we're here. And thank you for kind of echoing on that, because she asked the same question that I had. So without further ado, I'm going to hand it to Megan, introduce to us their office.
Hi, everybody. My name is Megan Cook. I'm with Republic Title. We're down at Coit and McDermott, about 12 minutes from here. I wanted to let you know we've got a couple of really exciting classes coming up. These are both CE classes, and they are strictly focused on marketing. It's a course that I wrote. It's called Beyond the Feed. We're going to talk about building your brand in September. And then in October, we're going to do advanced social media strategies. And then I will be, that same date in October, I'll be hopping over here to teach you guys the prospecting game right after that, which is an awesome class. So mark those on your calendars, please. They're at our office, which is great. And we're very excited about that. You guys also have in your packet some information about our office, who our closers are, the attorney page, our attorney helplines. So you guys can see all of Jay's information is right there. So you don't have to worry about writing it down quickly. And then the last thing I put in that little packet is our Plano Fast Facts. If you guys have an open house, I am happy to bring an open house kit, which has speaker, shoe covers, sign-in sheets, all of the things that you'll need, along with snacks and waters. And we'll give you some of those fast facts for whatever city you're having your open house in.
I have them. I have had them. They're so good. Thank you so much.
You're welcome. My job and all of our jobs is to help you get your real estate to the closing table. We know that's taking a lot more effort these days. So please call on us. We are here to help. We would love to partner with you guys and help you become more successful. So without further ado, we're going to start talking about contracts. Today we have Jay Turner, who I was telling him earlier. He is one of my absolute favorite attorneys. He speaks normal. He does not speak legalese. I can understand him, and I am not really law inclined. So you guys are going to learn a lot today. He is fantastic. He's been with Republic Title for, I don't know,
18 years.
18 years. So super experienced. Please bring your questions. Don't hesitate to ask. That's what we're here for. And if you're really confused about something, seriously, let us know. This is a conversation. We want to make sure that you walk out of here understanding the contract a little bit better, especially that paragraph 12. All right.
Introduce Tracy.
And yes, sorry, we have Tracy Horn here too. She is our manager and senior vice president of our Plano Allen office. She has been with Republic Title for many years and has probably dealt with every problem you can come up against in a real estate transaction and fixes them on the daily, multiple times a day. So if you have any questions, make sure you write her phone number down and then give her a call, because and you guys all have her card and my card as well. My cell phone number is on there. If you need something, text me first, because I probably am going to be in an appointment or somewhere where I can't answer my phone. So shoot me a text. I'll give you a call back as soon as I can. All right. You guys ready?
Good deal.
All right. Let's do it.
Awesome. Well, thank you for that stellar introduction. And thank you guys for braving the weather to get here. Honestly, you got a free car wash, right? I know I did, up Central Expressway to come to your office. And I was visiting earlier. Congratulations on combining your. I know I've seen a lot of you on Zoom classes. You sign up so often, and it's really good to see faces. Okay. I started in the title business when I was 32 years old in Coppell. Coppell Valley Ranch area. There were about 3,000 people in Coppell. Valley Ranch didn't exist. LBJ stopped at I-35. Okay. 114 was 2 lanes, undivided, with a 4-way stop at O'Connor. If you're familiar with that location, that goes into the Las Colinas area of the country club. Williams Square, Las Colinas, none of that was there. And so my point is, there's so much growth, and it's still happening, and it's happening here. And it's happening north of you. And cover up my name tag. This is my personal opinion. You couldn't be in a better place. So congratulations, and congratulations on continuing your education. You know how much I knew about the title business when I started 32 years ago, and I've been in it 40 years, so do the math. Nothing. I knew nothing. Okay. I had a law degree. I've been practicing for about 5 years. So what? But that did translate a little bit into real estate. I was able to read and understand a contract. Lender instructions were like reading Greek to me. But I was fortunate to have a lady that worked for me that was very experienced, and she taught me, one deal at a time. And so the point of that story is, and I always tell people when I have an opportunity to teach, especially contracts, experience is your best teacher. I can stand here all day long and go over these things and tell you and give you examples, but until it happens to you and you have to deal with it, you may not remember it. Okay. And so hopefully we'll talk about some of those things today. This is a non-CE class, so it's really a Q&A. I'm going to really ask you to lead me on things that you want to know about. I know one of the things that we were asked about to discuss was how to work through the commission paragraph 12 of the contract and the listing agreements and so forth. I have to tell you that the best thing I can refer you to, how many of you guys read the Texas Realtor magazine religiously? Okay, we need to increase that. Like for lawyers, we have the Texas Bar Journal, comes out monthly, and there are articles on current issues in that Bar Journal. There are also issues that have gone through court that give you examples of why this particular law will be upheld or will not be upheld. So your Texas Realtor magazine is outstanding for you, and it's in lay terms. I had Megan in our education department print this up. This is in your magazine, okay? And it was in January of this year, so it's current. And the title of it is Texas Realtors, How to Use Paragraph 12 in the Broker Compensation Agreements. So we'll look at that. Tina was kind enough to tell me of problems that she experiences and that she talks to among people. And I know at Republic Title, we get questions from agents and about this. And often it's like, you need the brokers to talk before you fill out this contract so that you know what to do. I can't help you really, because you've got the buyer's representation agreement, you've got the listing agreement, and you have the contract. And if you mind if we just jump into this right now and just get this out of the way? Fine. See if I can summarize it this way. And you know why all this changed, right? Because of the lawsuits and everything. Cool. So we still do it the traditional way, where in the listing agreement, the seller's going to pay all the commission. That's traditional. But in your buyer's rep agreement, the buyer may say, I'm going to pay my part. And then you look at 12 and you're like, well, what the heck does that mean? 12 just simply means that the seller is going to pay a portion, either a dollar amount or a percentage of the seller's commission. So that really means that they would have agreed under the buyer's rep agreement to pay something, and in the contract, they fill it in, and the buyer says, hey, I want to see if the seller will pay 1% or 2% or 5,000 or 10,000. And they put that in there, and the seller goes, no, I'm paying my broker, you pay your broker. So it's going to be, you don't even fill it in, or it'll be zero. So I think they're about ready, because Tina and I were talking right beforehand. She's got a phenomenal example, but when you call us for that, we'll probably refer you to the brokers so that you can ask them. So what's in the listing agreement? What's in the buyer rep agreement? And then what are we going to do about paragraph 12? Fair enough?
Absolutely.
Okay, take it away.
So for Jay, I brought up so that you guys, so you all can see this, this is just the residential real estate listing agreement, right? And how many of you are not with EXP today? How many of you, is everyone here with EXP? Okay, the reason I say that is the way you fill this out is per your broker's instructions. Okay? Your broker dictates how you're going to fill this out. And so when you say, how am I going to get paid? you're going to come to paragraph 5. And if you are with EXP, the way EXP requires it is you always fill out paragraph 5B 1A. And whatever percentage that you've negotiated with your client is what you would put in here. Or if you're doing it for a flat fee, then it would go in here. I happen to have this was taken from an example for an investor that I do. So you will not have both of these in your document. Okay. If you're doing a percentage, then you're going to do 5B, 1A, 2%, 3%, 4%, whatever you're going to do, or a flat fee. Okay. However you're doing it with your client. All right. This rules everything. So then when you put it out into the MLS, do yourself a favor and have a piece of paper, have a document in all your documents that say offer instructions. Because then we're going to come to how that person is going to fill out an offer, which is what Republic Title has provided for you today on the piece of paper. So you notice paragraph 12, okay? So because EXP has you fill out paragraph 5B1, your buyer will fill out paragraph 12. Guess what? Not our brokers are doing it this way.
Yeah.
So sometimes you're going to have a broker who fills out something in A. And if they fill out, for example, 5A1, then you're going to have a separate document called the broker to broker compensation agreement. Have you ever had anybody try to submit a broker agent compensation, broker to broker compensation? Okay. So when you have an offer, you're going to have to call that listing agent and say, how did you fill out the listing agreement? If they checked paragraph B, then on your offer, you're going to have paragraph 12. Does that make sense?
Mm-hmm.
If they say, no, my broker requires us to fill out A, then you're going to be required to not fill out paragraph 12, and you're going to have the broker to broker compensation agreement. Do you remember how on the offers that we used to fill out the bottom of page 10? You will not fill that out at all. Recently, I had someone put an offer in to me. Here's what they did. They filled out paragraph 12. They filled out the broker to broker compensation agreement, and they filled out the bottom of page 10. You are not, that's getting paid over and over and over, and you don't want your client paying 6, 12, 9%, and you're doing it on a Thursday and no. So you have to know your documents. So I'm going to let Jay take over, but it all starts with the listing agreement. So know your documents.
I could not have done that better. And so can y'all hear me okay? Do I need this? Okay. So I couldn't have done that any better. What I'd like for you to do, really, not right now, but later today, read through this, okay? And read through this. And then talk to the brokers and get any clarification you need. Because when we get a contract in one of our offices and it's been done incorrectly, which happens, what do? We call you. And we say, you need to call the other broker, because what do we need to close your transaction properly? A commission disbursement agreement, a CDA that tells us what to do. And so hopefully if there's been a problem filling it out incorrectly, no one caught it until closing, that it can be corrected with an amendment to the contract and the CDA. To me, this is going to be like several other new provisions in the contract. It's going to take a while for this to work out and for everybody to understand it. But now you know. Now I see some perplexed faces, and that's okay. But I would really recommend, this is a great article. Okay, and I've seen other great articles that I have saved. And a lot of times when an agent will call me with a question and it's one of these documents I've saved, I'll pull it up and I'll email it to them. And then I'll say, let's visit. And if it's a contract question, I'll say, let's pull up the contract and let's talk about it. And because I like to be as helpful as I can and teach when I can, because as I said, the experience is one of your best teachers. So can we leave that for a moment, or is there anything else y'all would like to talk about? Yes, sir.
I have a question about that. So that is the listing agreement, but whenever you get an offer in, let's say they fill out 5A, but then we go back to each piece and says, hey, we want to keep it from broker to broker. So they kind of tell us, you want talking to the thing?
Yeah. Jay, can I have that? Thank you.
So my question is, so let's say the listing agreement says they fill out 5A, and then let's say you submit an offer. I'm the buyer's agent, and EXP stances they want to keep it from being broker to broker because of the DOJ. Let's say I put it in 12A1B. Doesn't that also change, I guess, the way the deal is structured in a sense? I guess let me rephrase. Let me think what I'm trying to say. Even if they put their listing agreement as 5A, can we still get paid via 12A1B, having the seller pay us directly instead of broker to broker? Does that question make sense?
The commission is totally going to be governed by the listing agreement
Okay.
and what that says. To me, I think that's going to control.
Okay.
So if the contract is inconsistent with that, it's going to have to
Okay. So
be changed.
so listing agreement is going to be principal no matter what.
Yeah.
Okay.
And we don't make decisions on commission. Okay, we follow instructions. And so if the instructions, and if the instructions are ambiguous, we have to get them clarified.
Okay.
And who clarifies it? You do.
The listing agreement is the starting point.
Yep.
So if you have a listing. The listing agreement is your starting point. If you have the listing, then paragraph 12, like we just showed, is what you're going to fill out per your broker's instructions. So that rules. So that means anybody who presents a buyer on your listing has to follow that instruction. Therefore, when they fill out paragraph 12 of the 1-to-4 family contract, they are required, because of the listing agreement, to fill out 12A1B. Okay. If a broker chooses paragraph A in the listing agreement, it mandates this form, compensation agreement between brokers. Does that help clarify when you use it and when you don't? So what I say, when we have a listing agreement, just do ourselves a favor and put it in your listing documents as offer instructions. And you might copy that paragraph of what they need to put. Just copy this paragraph and show them you need to use this paragraph or explain it. That way you don't need an amendment to change it. And this, it's just clear.
Yeah, Tracy.
Oh, Tracy,
please.
yeah.
From a title perspective, that document, from a title perspective, that document, we get that probably less than 20% of the time. So if that's out there and it's different than what we're seeing in the contract, we may have the wrong thing in there, and probably 75% of the time, we're not getting a CDA until the day of closing or the
Right.
day before.
Right.
So it's really important for you all to share that with the title company so we can accurately prepare the closing disclosure.
Right. And I will say this, and you know this better than I do because you're actively in the branch, but we need that CDA as soon as possible. So a lot of times we have to provide that closing disclosure to a lender for a buyer. And so if the buyer is going to be paying any commission, we never know that. We need to have that in that agreement. So that's why we're asking for the CDAs quicker than we did before day of closing, So we need it prior to that. So we're all trying to be a little more proactive, not to delay a closing. Everybody's busy on closing day at the end of the month, and so it's hard to get those things in. Do it sooner, and that will help us help you. Right?
Okay, I just want to add a little bit insight to answer the question from Brandon about if a buyer's agent. We have a lot of agents out there. They're not like us. Will
Yeah.
attend all the trainings all the time. They don't know how to fill out that form. Still, it's been almost a year now. So I see this all the time. The buyer's agent will fill out 12A1C and the compensation, and they require you to fill it out. Okay, what happens? Technically or legally, according to the attorney, please correct me if I'm wrong. If you fill out the 12A1B here, and you fill out the 3% on the page 10, and you fill out compensation of brokers, legally, they're supposed to pay you twice. They're supposed to pay you out of the seller's pocket and out of the broker. However, it doesn't happen. Most of the agents just say, "Oh, that's not what we meant. You're just gonna get 3%." Okay, so that's fine. We're not gonna argue. We're not gonna sue them to courts, right? However, legally, if they fill out both places, they will pay you from two different sources, and that's the reason why we have the 12A1B and the broker to broker compensation, because broker compensation is coming from the broker and this is from the seller. However, there are cases you could filling out both of them, but they may add up to be a 3. So maybe the seller will have a agreement with the seller's agent, with the listing agent, say, "Hey, I'm going to pay you this much, and the concession on the buyer side, I'm only paying this much." And then altogether, the buyer's agent will get this much. So you could, I don't know how you're going to divide up. It's very rare. It has happened before. So it's all through negotiation, the process, and maybe sometimes you have to amend the listing agreement or amend the buyer representation agreement. It's all a negotiation. So, but it should happen at the time when you sign the contract. It should happen before the negotiation should happen before you sign the contract. So communicate with the other agent. Talk about it, how much you want to get if you're a representing buyer, and where that money is coming from. It could come from the broker, the other broker. It could come from the seller, and that's where you need to fill out, right? Remember, seller is on 12A1B. Broker is on broker to broker compensation. Oh, Jim has.
That was, you answered it. Never mind. I had the same situation where I told them if they did page 10 and 12A, it would be double, and they didn't believe me. So then I had to sit down and talk to them like for 15 minutes. Yeah. And then I had them call their broker, and their broker told them no, 12A1B is only for seller concessions. Even the broker was wrong. And then I talked to EXP's broker, our broker, had him on the phone and sent the email, and their broker is still like, no. And it's Global Realty, just in case anyone wants to know. But but then at the end of the day, after about 3 days, they decided, after they called Trek, I guess. So they were he wasn't trying to get paid twice. He just didn't understand. And even his broker didn't understand the rules. Yeah.
Well,
We have seen that a lot, especially earlier this year. Lots of people are just doing both, and we kind of just went with that. If I don't have I can't educate the other broker, right? I can only educate myself and maybe some of my team members. So, what I was going to say, technically, or again, Mr. Turner, correct me, that 12A1B is seller concession. So that is seller concession. So technically, you can say the buyer's agent commission is coming out of the seller's concession. So that if the broker said, that's seller concession, yes, it is seller concession, but the BAC is coming out of the seller concession. That's my understanding. Please correct me if I'm wrong.
Well, the way I read that is that the buyer in the buyer's rep agreement has agreed to pay some money. Okay. And so the seller said, "Hey, I'll pay a portion of that." To me, that's what 12B says.
I think the other thing that confuses a lot of people is 12A1B, it says buyer has agreed, but I keep pointing them back to 12A, seller shall pay. So then I always try to explain it to people. Seller shall pay, and then everything under is still seller, no matter what it says.
Mhm.
You see how it says on the.
Well,
on the
yeah.
ARV, it says buyer,
Yes.
yeah, and that's what throws a lot of agents off, is that.
Can I, yeah.
Yeah, Tracy.
Yeah,
Exactly.
But can I say something about that? Because my understanding is that that sentence basically saying the buyer has agreed to pay.
The buyer has agreed to
Yeah,
pay.
doesn't mean the buyer is paying. So this is totally the kind of a very confusing
It is.
law attorney language.
It is.
Basically, it's saying seller is paying, but this is the amount the buyer has agreed. So that's
I've got to,
I think really only pertaining to compensation.
right.
correct.
1C is the seller paid cost.
That's correct.
True.
That's
Yeah.
correct.
So 12A1B is compensation. 12A1C is towards repairs and other
You
stuff.
know, keep this in mind as well. The entire contract forms, all of the forms that you use are promulgated by TREC through the broker lawyer committee. And so that committee is appointed every year by TREC. They serve different terms. And so these people get together and write this language. And so that was their best attempt at that revision. I suspect that with all the issues that have happened in this last year, that this is going to get addressed again and try to clarify it a little bit for everybody. So what the title industry can do is say, we get problems on this all the time. And so we reach out to the lawyers that are on that broker lawyer committee. And for you, either through the brokers or someone else, reach out to the brokers that are on that committee. I assure you they know, and say, work on this, please. And let's see if we can get this clarified, because what are we all charged with? The contract. You know, we have to follow the contract. A lot of times we'll get a phone call, you know, you need to do this or this or this. I'm like, well, okay, we follow the contract and this is what the language says. And then a lot of times the caller goes, yeah, but. And I'm like, okay, I understand. I hear what you're saying, but there's not a but. What this contract says is this. Now, if you want to change it, fine. Go amend the contract. But our duty as a title agent is to follow the terms of the contract. So hopefully it'll get changed.
I was in
All right.
a meeting last week and there was an attorney there that I guess sits on the committee.
Great.
And they're going to revise this paragraph.
Awesome.
from what I've been told.
I told you.
We already know
Great.
they have to
So,
change
this
it.
is not the
Great.
official verbiage, but this is what he said they're proposing. Okay,
That's
so let me
awesome.
see if I can get this right.
Okay.
Okay. The amount not to exceed, and then this is all taken out. And then you put in this.
A
you know,
dollar
your
or a
line. The amount
percentage.
not to exceed will be applied toward the brokerage fees owned by buyer to buyer's broker.
Yay.
Owned by buyer to buyer's broker.
Excellent. Yeah.
That's their
Yeah.
attempt to clarify the confusion.
Good.
So
Yay.
just know that we're gonna have a contract revision coming up. But for now, what
This
we're
is it,
working with,
yeah.
okay?
And we'll be on the front, we'll be on the front lines with a red
They
line.
can do anything
Okay.
after that.
Here's what you can do, because it's in proposal mode, you can actually go into TREC and you can look at the proposed changes. You can read them and you can comment on them. They want your
And please
comments as
do.
agents, so that they know what you all in the field
Right,
think
right.
about this proposed. You'll see the verbiage if you go into TREC on the forms, not just on this, but other. Go in, make your comments, let it be heard, that way they can modify and adapt. as
Absolutely.
more people respond to it.
Tina, I have a question before you move on.
Yeah.
Paragraph 11, special provisions. Is this an example like of a list offer that you submitted?
Okay, this was a crazy, I'm sorry, we're not getting into special provisions.
Thank you. Hey, can I tell you something real quick?
Don't even read that.
Yeah.
That
No,
sounds crazy,
no,
but
no.
that seller and that buyer that
No,
Yeah,
no,
I'm
no.
finding a needle in a haystack.
Special provisions paragraph used to be about that much on the blank.
Yeah.
And finally, it's this, thank you. Because as a lawyer, I would read things that either parties or agents, and trust me, not all agents are created equal, and they don't all get the education that you guys get. And you'd read language, and you're like, I have no idea what that means. And the parties have signed that contract. I have no clue what that means. And so I'd call both sides, both agents, help me understand what you're trying to get to here. And they go, oh, and well, that's not what this says. You know, and then we'd try to help them massage it and get the right language because we're stuck with the contract. So bottom line is when I teach contracts, stay out of 11.
Exactly.
Stay out of 11 unless it is
It's
a
factual.
business fact.
Yeah.
You know, no what ifs, but just
But you were
Understand.
very wise to get your broker. So
Yes.
if you have an agent saying, no, my broker says this, well, guess how I learned all this? I had an offer come in on a contract and
Yeah.
they wanted to use the broker to broker compensation. And I said, no, we have to do paragraph 12. Well, no, my broker says, well, my broker says.
Mhm.
And so I called the brokers, do your Texas broker hotline or go into, online or however you're going to contact them. And they explained it to me. And that's how I learned listing agreement rules. So if you have a buyer's agent coming in on the opposite side, just say, hey, if you're still confused, I'd love for my broker to be able to talk with your broker.
Yep.
Because this is how my broker requires it.
perfect.
And it gets you out of the mess.
Perfect.
Okay.
And one of the best things that I think you said is the offer instructions to make an attachment. That'll probably save you a lot of time and headache. I think that's a great idea
Mhm,
to attach that.
mhm.
Okay. We have 15 minutes left. Um,
That's a biggie because that's how y'all get paid. So.
Yeah. Anything else specific? Because I have a couple other things I want to talk briefly about, but anything else that y'all want to talk about contract wise? Yeah, okay. I have taught a class, I think in person and also on Zoom several times. The bulk of that class talks about FERTA, okay, which is the federal, Foreign Investment and Real Property Tax Act of 1980 that requires the withholding of money from a seller who is foreign under the definition of the Internal Revenue Code regs, okay? And if you recall these classes, the foreign definition is not a United States citizen, not a permanent resident alien with a green card, or there's a third exemption, and that is they meet the substantial presence test. The substantial presence test is a factual determination that's set out in the IRS regs that the person meets the qualifications of that test if they have resided in the United States for so many years in the current year, so many days in the year preceding the current year, and so many days in the year preceding that year. It's a very confusing regulation, as are most of the IRS regs, okay? But first of all, it's not a tax, it's withholding, okay? All of us, citizen, resident, permanent resident, when they sell real estate are subject to capital gains tax, okay? You buy a house for 100,000, you sell it later for 500,000, your gain is, in my simple example, is 400,000. You pay tax on that gain. All of us, me, you, anybody that sells, with certain exceptions. If it's homestead and you're married, you get up to $500,000 of an exemption. So in my example, you owe no capital gain. If you're single, it's 250. And so your gain would be 150. All right. For people that are citizens of the United States or permanent resident alien with a green card, or they meet the substantial presence test, there's no withholding. But for those that don't meet those three exceptions, the regs say that the buyer is responsible for withholding from the seller and remitting the money to the IRS with the appropriate tax forms. That obligation is on the buyer. And if the withholding is due and it's not collected, the buyer is liable. There's a lien placed on the house by the IRS when they find out about it that can be foreclosed, and it wipes out any mortgage. It has priority over a mortgage lien, and it is not covered by title insurance. Okay? Now, just like all of us, you settle up with the IRS at the end of the year, or whenever you file your tax return for the current year, and you settle up. Hey, I sold a house, and there's a form for that. Here's what I paid. Here are the improvements I put in. This is my basis. This is my gain. Transfers over to your 1040, and you either owe tax or you don't. The same with a foreign person. They either get it back, all of it, or part of it. And so, why am I telling you all that? It's in paragraph 20. So look at paragraph 20 real quick. Nowhere will you find the word FIRPTA. Nowhere will you find the words Foreign Investment in Real Property Tax Act. It's not there. I would love for the Broker Lawyer Committee to revise this one as well, because people don't understand it. They get mad a lot of times when they say, hey, this might apply. And from the title company perspective, we don't make the decision if it applies or not. Okay? Under the regs, the buyer is called a withholding agent. The IRS regs call the buyer the withholding agent and place that obligation on the buyer. And so if you look at 20, it says if the seller is a foreign person, and you notice that is in quotation marks, okay? Comma, as defined by the Internal Revenue Code and its regulations. So I just told you, not a citizen, not a permanent resident alien with a green card. The third is the substantial presence test. And then it says, or if the seller fails to deliver an affidavit or a certificate of non-foreign status to the buyer, that seller is not a foreign person. Okay, what are they talking about there? In section 1445 of the Internal Revenue Code, there is what's called a certificate of non-foreign status. It's not really an affidavit, but that's what they put in here. It's a certificate. It's a form. It's a one-page form. And it essentially says, here's my name, here's my address, here's my tax ID number or my social security number, and I sign it. And it says, I'm not subject to backup withholding. Nowhere does it say FIRPTA. Nowhere does it say Foreign Investment in Real Property Tax Act. That's just what the certificate says. But the backup withholding means I'm not liable for it. And the seller is obligated to give that to the buyer. And then sellers go, wait a minute, that's got my social security number, my tax ID. I'm not giving that to anybody. Well, sorry. The regs say you have to. Just part of the deal. You go, why? Because if it turns out later that the IRS says that the seller's lying and they really owe the money, and they come after the buyer, they send the nasty, scary letter, you owe $50,000 plus penalty and interest, and we're going to foreclose on your house if you don't pay this. And the buyer goes, wait a minute, I have a certificate of non-foreign status that the seller signed. That's a defense to the buyer. And the buyer goes, wait a minute, I got this. Now, the IRS may prove its authenticity, and they go, yep, you're right. And they try to go find the seller. That paper is worthless if the parties are aware that it's untrue. That's fraud. In other words, buyer and seller may know each other, and the seller, hey, I'm going to give you this certificate. It really is due, but I don't want to pay it because it's a lot of money. You know, if they come after you, I'll pay it. Okay, so wink, wink, I'm going to give you this certificate. That's fraud. And if you get a sniff of that, you get out. Because there's criminal liabilities for fraud. Okay, so why am I telling you all that? Well, it goes on to say, buyer shall, not title company, not the agents, buyer shall withhold from the sales proceeds an amount sufficient to comply with the tax law and deliver the same to the Internal Revenue Service. There are some title companies that don't touch that with a 10-foot pole. That's up to the parties completely to figure it out. There are some title companies that will assist in that. We're one of those. Again, the reason I want to talk about it is because President Trump issued an executive order directing the IRS to change the method of remittance of the money and placing that obligation more completely on the buyer, not us. Because what we've done in the past is given that we'll collect it, we'll cut the check, and we send the check to the IRS. What they're trying to do in this executive order is say you can't do a paper check anymore. All payments to the government have to be through ACH, and it has to be done by the buyer. That's going to be so difficult. So we're not changing anything right now, the way we do things. We are following this very closely. There's a company that I like personally. All they do is FERPTA. They're in Houston. The guy that owns it and runs it, he's connected with American Land Title Association, Texas Land Title Association, certified financial planners, CPAs. I mean, he's got all these letters after his name, more in the alphabet. But he's what is known as an enrolled agent with the IRS. So he has direct access to IRS records. So he can go into the IRS records and make a factual determination that someone meets the substantial presence test just by looking at the tax returns they filed, and presents a letter and a certificate of non-foreign status for a buyer. Now, last time I checked, it was about $1,500, but I've had sellers call me and thank me for that referral because they don't want their $50 or $60 or $70 or $80,000 sitting at the IRS when they know they're going to get it back because their tax structure for that year. So I don't want to beat that up anymore. I just want to tell you that that change may come. We're following it. If it does, we'll let you know. Okay. They put a date of September 30th for implementation, and our contacts are like, forget it. The IRS is so backlogged. They don't even have the processes in place, okay, for it to be done. It will also require, if this goes into effect, the seller and the buyer to have taxpayer ID numbers. So many times we get down to closing and like, what's your, especially people that aren't citizens, what's your social? Don't have one. What's your taxpayer ID number? Don't have one. You need to get one, or it will delay closing.
I have a couple of things I just want to offer
Please.
that I think
Yeah.
are good for, if you want to be a good agent and help your clients, if you are helping them on a purchase and you know they're a foreign person, make them aware of this at that time. So they don't come back to you later and they're mad about this FERPTA that they didn't know about.
Right.
A. B, we're seeing a whole lot of price points, lower price points now, like under 300,000. I mean, I'm seeing a lot more than I've seen in the last several years. And if you are listing a property under 300,000 and you're entertaining multiple offers, maybe pick the one where the buyer's going to occupy the property. In that event, we don't have to do FERPTA withholding at all. If it's an investor buying it, then you do. So if you've got multiple offers, maybe for your seller, it's better to choose that offer where the buyer's going to live in the house
If
and
it's under
avoid the
300.
FERPTA altogether.
It's a mess. But I'm hopeful, and I may do what I can to comment to make this paragraph a little more understandable for people. Like maybe, what are you talking about? What is the Federal Foreign Investment Real Property Tax Act? Who's responsible? Who does what? So we can have boxes to check in there that y'all can talk about. It's also in the listing agreement, folks. Anybody that does a lot of listings, it should be in your listing agreement. It won't say Foreign Investment Real Property Tax Act. It will just say, is seller a foreign person under the definition, or is a seller a United States citizen? Yes or no? If no, the seller a permanent resident alien with a green card? Yes or no? So in other words, at the listing, you're trying to ferret out whether or not FERPTA is going to be due. Thank you.
This is
Well,
the
I love
listing
you.
agreement. This is
Yeah.
paragraph H. Okay,
Yeah.
so number one, don't make the mistake of filling this in for your seller.
Amen.
Do not ever fill this in. Don't fill in if they're delinquent. Oh, I know Harry. Harry would never be delinquent on a loan. I'll put no delinquent, no liens. I know he'd never be bad. Always make your seller fill in those blanks. The same thing here.
Right.
Okay. And if they're not sure, if you have any doubt, then you need to have them find out or speak to the broker or speak to the attorney at the title company to find out, do they qualify as a foreign person or not, to get that
And I'll
clear
tell
on the
you,
front end. And if they are, then you might want to have some type of documentation in your listing agreement to let the buyer know how that will impact. Same thing. If you think there's any chance you're buying a property where there might be a foreign
Mhm.
seller, then maybe you need to have that documented. Maybe a standard operating procedure is we have a questionnaire we send out to the buyers, to the listing agent saying, hey, what paragraph did you fill out in your listing agreement? And is the seller a foreign person as defined in paragraph H? Don't do the definition yourself.
no.
Just say as paragraph H. Does that sound good, Jay, to protect
It
them? And
it
their
does. There's a lot of moving parts to this. It's a small paragraph. There are no blanks to fill in on the Trek contract. There are no dollar amount, no boxes checked. There's nothing. It's just a statement. What's a statement in a contract? It's a contractual obligation of who? The parties. It's not a contractual obligation for you. It's not a contractual obligation for the title company. It's for us to follow the instructions. There aren't any instructions there. Read 20. It just says, if this, then that. If seller is, then they got to do this for the buyer. So as a listing agent, you need to ferret it out in the beginning. If you're a buyer's agent, you need to ask that question. Now, what we have done is when we send out, thank you for the contract, here's a seller's information sheet. We would like to know these things. It includes, what do you have a loan? What's the loan number? Who's mortgage company? What's their contact information? So we can get order payoff in writing. But the first thing we talk about is, for a seller, are you a United States citizen? Yes or no? If they check yes, we move on. If they check no, the next question is, are you a permanent resident alien with a green card? Yes or no? If they check yes, we move on. If they check no, and they've also checked no to I'm not a citizen, then we'll notify both agents. Hey, based on answers we've gotten from the seller, the seller may be subject to federal withholding under this act. Contact your tax professional, because what we can't do is take the phone call and say, yes, it applies, or no, it doesn't. If they check no and no, but they say, hey, I'm here under an HB1 visa and I've been here for 10 years, so it doesn't apply to me. Okay, talk to the buyer, because it's the buyer that you need to give that certificate of non-foreign status to, not to me. Now, I want a copy of it so that we know it's been done. But you have to communicate with the buyer.
Hey, Jay,
Yes.
I think a lot of people are dealing with earnest money because deals may be falling out.
Okay.
And I noticed you had the release of earnest money
Okay,
form in
great
this.
question.
Can you
Yes.
go over why
Yes.
it's so important to
Yes.
why you have to and all the
Yes.
ramifications
Yes.
if you don't?
And this, what I'm about to say, may be different than what you hear from other title companies, but I'm telling you, we do it the right way. I won't name names. If your buyer, and I think there's one instance in the contract where the seller has a termination right, and that's where the earnest money has not come in, okay, within the time prescribed. Seller has a right to terminate the contract if that termination gets delivered to the buyer before the buyer gets the earnest money to the title company. So it's really literally a race to the title company, because if we don't get it in a timely manner, people say, well, the contract's void. No, it's not. It's not. You just have a default. Default is they haven't given the earnest money. So what are the remedies under default? For a seller, terminate and get the earnest money. Duh, there's not any. But terminate. They have the right to terminate. We've literally had this happen where a buyer is driving like crazy to get to the title company. Should have done a wire, but they're not, to drop off some money. But we get a copy of a termination
First.
by email first.
Yeah.
And what do? We look at the effective date of the contract. Hopefully it's filled in, and then we just count. And then we look at the email that they gave us. When did they send that to the buyer or the buyer's agent? Because that email from the seller is date and time stamped. And I don't care if we're reading that and the buyer comes rushing in with a check. If that time and date is before that buyer comes in with a check, the contract says it's terminated. And we will cut the check back to the buyer or to the seller in that case, if they want it. Now, on the buyer's side, there are many places in a contract where a buyer has a right to terminate within so many days after something happens, right? Like option fee, you fill that in.
Title commitment,
What's that?
title commitment review.
Title commitment review, survey review, the hidden option that I always like to say, the delivery of the covenants, conditions, and restrictions. They've got 3 days after receipt of those documents to terminate the contract. And they don't even have to cite a reason in those documents. They just say, nah, I don't want this house. If they're within that 3 days, they have the right to terminate. Okay, I hadn't pulled it up, but it's in there. Don't move this. Paragraph 21 is so important. That's the notice section of the contract. All notices are effective. That means they're good. They're effective when delivered, in the following manner. My recommendation is email. Put the buyers and sellers email in there and copy you. And the reason I say that, I love it. You got to go with me when we do more classes.
I was like, this is the best I've ever seen this class. This is awesome.
So where was I? I got so excited.
With the
Oh,
notices and making sure that they're sent to you via
yeah,
email.
21. The reason I like the party's email is because of the language in the contract. It says the notice is effective. Notice to terminate. You check one of these boxes. Notice to terminate. It's effective when delivered. Well, it's delivered when you hit send. If you have emailed it to the address in paragraph 21, it is effective when you hit send. So you CC yourself on that email. So boom, you automatically have a copy of the email that got sent with a notice, and then you flip it to us. Don't just send it to us because 21 says it goes to the parties. Okay. And so what we do, we look at it, we look at the effective date, we look at the contract provision. Yep, that's valid. Contract's dead because that's what the contract says. What I say is if they've got the right to terminate under the contract, don't use this. Why? Why? Because the contract controls, okay? And the contract says they've got the right to terminate and you've done it timely. You did it in accordance with paragraph 21. That's all you need, in our opinion. Because if you're sending the notice to terminate and this, and you fill it in that all the earnest money goes to the buyer and that went to the seller, sort of goes, oh no, I get it. Right, wrong, or indifferent, they say, no, I get it. They're mad, whatever. And that's usually the case. They're wrong, but they're mad. And so what do we get? We get this from the buyer that says the buyer gets the earnest money. And we get this from the seller that says the seller gets the earnest money. I can't cut the baby in half. So what do? We hold it. How long do we hold it? We've got files indefinitely. It's terrible. I worked a bunch of those one time and I would call the agent and say, oh, that house is sold 3 times. I said, all right, we're going to give the money to so-and-so. I'm going to make the call. I don't like to do that. And we don't do it very often, but nonetheless. So if you're outside of that period that your party has the right to terminate, that's when you use this. Okay. And this is the release of earnest money between the seller and buyer. And look, it says it releases the parties, buyer and seller, the brokers, and the title company from all liability under the contract, not just disbursement of the earnest money. So it's releasing the contract. Don't sign it if it's not your intention to release everybody from liability. And if you don't understand it, contact your attorney. And then again, it says they release everybody and the escrow agent and directs the escrow agent to release the money in this manner. I don't care if it's $100 and $900. I don't care if they split it. I don't care. But it's got to be mutual.
So can we give a real live example, Jay?
Please.
Okay. So let's say you had a contract and everything's going along, and for some reason the deal just doesn't work out. Okay. You've terminated the contract.
Yep.
And the title company still has the earnest money and option fee. Well, obviously the option fee goes to the seller, correct?
Never, ever, ever goes back to the buyer.
Never.
Never, period.
Okay. But you can't assume that just because you did a termination of contract, oh, well, then the title company is going to release the earnest money.
Uh-uh.
They have to have instructions to do that and to who, right? So let's say you forget to do that. Like Jay said, they're going to have it. They don't know what to do with it. Do I give you $1, you $10, you $5? You know, they don't know, right? The other thing that seller cannot enter, if correct me if I'm wrong, please, that seller cannot enter into another executed contract until this is done. Because right now, that money is still tied to this property because it says release of all affiliation. So that's what I've been taught is,
Well, that's where we might
I don't want to
differ.
get in. Okay. I would love your clarification
Okay.
because I've
Our
had another title
clarification-
company.
Our clarification is that this releases the contract obligations and releases everybody under the contract obligations. The only
by
issue-
doing it.
By doing it. The
Right.
only issue is who
I'm
gets
saying
the
if they
earnest money.
didn't do it,
Or if they did not.
if
do
they
it.
did not. If they did
Okay.
not release the earnest money, they terminated the contract,
Yes.
but nobody released the earnest money.
Right.
The earnest money is still associated with 123 Elm or whatever the
Right.
property.
Right?
What I was told by another title company, please correct me because
Okay.
we get different answers,
I know.
is that that property legally is bound to that earnest money right now until it's decided what to do with it. So you want to, if you have the buyer, you want to resolve this because you don't want tied up either. And you don't want the seller tied up if you have the listing because you want another offer. Now, please
That's-
explain. I
that's-
appreciate that.
No, and I understand that, and I've heard that many times, but what we have agreed
Okay.
amongst ourselves, the attorneys at Republic, is that this language releases the contract, releases all the parties from the contract.
But that's why I'm
Not-
saying you do it. What happens if they don't fill out this?
At
And the
all?
earnest money is,
If
they
they don't fill-
terminated the contract, but you still have
Using the notice
earnest
to
money.
terminate,
Mhm.
but they haven't done this,
Correct,
and they don't have the right to terminate under the contract,
correct.
yeah, then the contract's not released.
Right.
What I'm saying is if they do this form and they sign it and the brokers sign it, our opinion is it releases the obligations under the contract, and the only issue is who gets the earnest money. That's the only thing that's disputed,
Mhm.
is who gets the earnest money. Okay? So if this comes in, forget the notice to terminate. We're outside of all the available options to terminate under the contract. There aren't any. They just get to closing and the buyer walks in and goes, forget it, I'm not doing it. And I've had that happen.
Mhm.
Then this is what we require. If this doesn't come in, we will not take another contract. And any other title company that does is doing it at their own risk because that contract is still alive. However, our opinion is if both sides sign this and the only issue is who's getting the earnest money, then we say contract's terminated. The only issue they're fighting about is earnest money, and we will take another contract.
Okay. Does that clarify you guys' questions?
Yeah, I had one question. So when it says release of liabilities,
Mhm.
that means the buyer cannot come back and
That's
sue the
correct.
seller
That's correct.
or vice versa,
That's
right? Okay. Yep. That's what I,
Think about it.
yeah.
If you read the default section of the contract, they can do this or they can sue for damages.
It's not both.
It's not both. I literally, I closed a lot in my early days, but I had a buyer walk in, sit down, I had the package there, and he goes, I'm not closing. And I said, excuse me? I said, I'm not closing. I said, like right now or forever? And he goes, forever. I don't want this house. He goes, what are my rights? And I'm like, your rights are spelled out in the contract. Well, you're a lawyer. What are my rights? I said, I am a lawyer, but I'm not your lawyer. I said, now you can use my telephone and you can call your lawyer, which I highly suggest you do. And I'm going to go out and get some soft drinks and some coffee, and I'll give you about 10 or 15 minutes to talk about it. And I came back in, he goes, nope, I'm terminating. I said, fine, thank you. And I called the listing agent, who's a very good client of mine, and told her, and she's like, oh my God, the people are on their way to Florida and they're expecting this money because they're closing on another house tomorrow. Well, guess what? They sued the buyer because what are their damages?
Yeah.
They're huge. If that deal ended up closing, it closed somewhere else, not with me.
And they're not
But-
releasing that earnest
and
money.
we're not
I
releasing the
guarantee
earnest
you.
money. Tracy?
So Jay, we know there's the stipulation about demand in the contract. So one party,
Okay, yep,
one party puts this in
yep.
and the
Thank
other
you.
party doesn't respond and the 15 days pass and then we can release the earnest money.
Right. That's in 18C of your
What does that
contract.
mean for the contract
Okay,
if there's no response in the 15 days?
okay. This is great because if we get the release of earnest money and it only comes from one side, okay, we don't get it from both sides, we consider that a demand. And under the contract, it says if we send a copy of that written demand to the other side, let's say we get it from the buyer's out, we don't get anything from the seller. We send a copy of that demand to the seller. Say enclosed is a copy of the written demand we received from the buyer. That's all we say. Because I'm not giving them any legal advice. Because under this contract, it says if they don't respond within 15 days, the contract terminates and we release the earnest money to the buyer. And so we have this tricky little letter that I drafted a long time ago. It's about 2 lines. And I'm like, I'm not telling you, okay, you need to go look at C and you need to make sure that you respond within 15 days. That's giving legal advice. I'm not doing that. All I'm doing, all my obligation is as an escrow agent is to promptly provide a copy of the demand to the other party. I literally say, dear other party, in connection with your contract, we have received the enclosed written demand, release of earnest money on this property. Boom, sincerely, Jay Turner, attorney at law, da, da, da. And then we tell the office, put a tickler in your file. And the minute you come into the office, you check and see if you've gotten any emails, anything that would constitute something from the other party. And if you don't, you cut the check and call them. I guess what I'm saying is if you have the option to terminate, don't combine it with this because you risk muddying the water. Now, where we have conflicting demands, where both sides have said, I want it, we also have an attorney letter that we'll send out that I find is very helpful to say, hey, we've got these competing demands. We can't decide who's right or wrong. We're following the contract, but we do have the right to interplead this money in a court if y'all can't decide who gets it. Interpleader is an action in district court where you basically file a lawsuit, you serve the parties, and you say, Judge, this money was deposited for this transaction. Both sides have terminated and saying that they want the money. We have conflicting demands and we can't decide that. So here's the money. And the parties are now before the court because we've served them. You decide. And by the way, here's our motion to withdraw us as the plaintiff because we have no dog in this fight. Now you have money. And those people get to go to court and tell their story and somebody gets it. And oh, by the way, Judge, we get to recover our attorney's fees and court costs for filing the suit, which is nowadays about $1,500 to $2,000, $1,500 to $2,000. So I'll usually call people when they're in this headbutt. Oh, you're only talking about $5,000 earnest money. If I have to do this, it's going to cost you $2,000 probably. If you want to do it, it's fine. Whatever you want to do, but I would suggest that y'all get on the phone and figure out a way to work this out. And it's amazing how we usually we're going to split it.
And can I just make an interjection? Jay made a very, very important point, and I don't want it to go unnoticed. Under your section for notices, let's say you get a notice, but you don't give it to your buyer or seller. The parties to the contract did not get the
That's
notice.
correct.
Does that make sense?
That's a great point.
So then you are in doo-doo,
Yeah.
deep doo-doo as their agent.
Yep.
Because just because you found out
You were negligent.
and then fill in the blank, they terminated or they wanted an option period or whatever it is. If you didn't give that notice to your client did not get the notice. So make sure, a lot of people don't want to fill out that notices section and put their client's information.
Please.
That's how the title company has authorization, or the survey company, or the whoever.
Right.
That is saying, I want you to contact Mr. and Mrs. Smith at this phone number and this email address, and copy me.
Yeah. Yeah.
If you're saying you're not going to put in your client's contact information and it all goes through you, you are more liable now for every
Totally.
single bit of
Totally.
information
What if you're out
versus
of
if you're
town? What if you're in
copied.
the hospital? What if you're in a coma? What if you're in a car wreck? You get the notice, but you can't deliver it to the party. You're
Okay. So
Right.
please start putting your client's information in there
And don't
and
put
explain to them why.
I'm sorry, you just hit a hot button for me. I had an agent put their office address one time in the notice section for the buyer. Okay, fine. So the covenants, conditions, restrictions, and the HOA information went to the agent's office at their office address by FedEx.
And the client never got it.
Client never got it.
Guess who's
what?
in default?
The property had so many deficiencies when the HOA inspected it. I'd never seen a list that long. And at closing, the buyer is accepting and assuming the responsibility for bringing the property up to standard. Had they done it properly, the buyer would have seen that early on and said, no, seller, I need you to fix all these things. And the seller could have said, okay, fine, I will. And you negotiate that. Or the seller said, no, I'm giving you such a good deal. I'm not doing anything. But at least the buyer has noticed.
Yeah.
And in my case, the buyer didn't. And when I handed him that paper at closing, he said, what's this? What are you talking about? And I told him, and the agent goes, yeah, we never got that. And I'm like, oh, great, we screwed up. I mean, that's, I'm like, what did I drop the ball on? We have a wonderful computer system. So I go out, I pull up the FedEx, the receipt of the FedEx delivery, the transmittal letter, and the copy of the HOA docs. And I didn't want to throw the agent under the bus, but I went back to the room and I said, I need to talk to you for a second. And I said, who is Betty? Got him out in the hallway. Well, Betty's my receptionist. He's pretty indignant at this point. She's my receptionist. I said, well, Betty signed for this information on this day. Here's the FedEx receipt. I'm going to give you some time with your client. I'll be back whenever you're ready. Let me know. And when I went back in the closing room, he had his checkbook out. Now that's sad.
Yeah.
And that could have been avoided had they put in the buyer's email address. I don't care if the buyer doesn't look at it. That's on the buyer. The seller's off the hook if it's sent properly. Okay. Thank you for bringing that up.
That's a big one.
It is a big one.
Mhm.
And it's in the contract. There's two other things, and then we probably should wrap up so you guys can go. And I'll talk about it later if we need to.
Can I just suggest, you guys, I know we use these contracts a lot and sometimes we get numb to what they say because you're used to just filling in the blanks.
Right.
But can I just encourage you between now and next Wednesday when we meet to get out those contracts and reread them,
Yeah.
just to refresh your memory as
Yep.
to what they say
Yep.
so that you can negotiate the best deal on behalf of your client.
I should not have said that better. I should not have said that better. Thank you. And when agents call me, a lot of times I will say, let's look at it together. Two other quick points and I'll stop. We can talk about this in more detail at a subsequent meeting if you want. I know you're probably all have heard, if you haven't, you probably will, that the Texas legislature passed a law on prohibition of sales to people from 4 countries. Iran, North Korea, Russia, and China.
Yeah, we've had a lot of questions about that.
I know.
To schedule.
I know.
Yes.
I will
Yeah,
tell
we
you that
request
we-
another session for that.
That's fine. I will tell you briefly that there was a bill it was specifically pulled out of the bill. Title companies have no obligation at all to make that determination. We will not investigate it. We will not vet it. And that's totally on the buyer.
Mr. Turner, have you been, read through the bill
Yes,
already? Okay.
yes, we all have. But here's another thing I'll say. Texas is not the only state that's passed a similar bill. Other states have. I think they'll be challenged. But at least now it's there. And so the question for you is, what do I do? For you, unless any of you are a lawyer and want to take on that liability, you tell your client, if they ask you, if they're from one of those countries, I don't know, you need to speak to your own attorney about the potential risks that there may be under that law. That's all we can tell you at this point. The governor has the right to add more countries, which to me is probably unconstitutional, but at least he does. So anyway, I just want to bring that to your attention. It's called Senate Bill 17, Texas Senate Bill 17. So if you want to look that up, you want to Google that. But for you as an agent and you have a client from one of those countries, encourage them to contact their own attorney and just say, you told me that. I just need to tell you that there is a law in the books. You need to contact an attorney and satisfy yourself. Same thing on FIRPTA, folks. Refer them to a tax professional. And unless you're a CPA and want to assume that liability, or unless you're a tax lawyer, you don't know the answer to this question, refer them to a tax professional. That's where I think this is leading. That it's just like going to get an appraisal, going to get a survey, going to get a home inspection. Oh, FIRPTA may apply. I need to talk to a tax professional. It's just one of those things that people are going to have to get used to doing. Okay. The other thing, briefly want to touch on is FinCEN. That is the acronym FINCEN. It's the Financial Crimes Enforcement Network. It's through the Department of Homeland Security, and their charge is to watch and check out money laundering. Okay. The burden has now been placed on title companies to ferret out some of the issues. So on FinCEN, if it is a cash transaction, okay, and seller or buyer is an entity, meaning an Inc., an LLC, a partnership, even a trust, then what it requires us to do is obtain information from the party about the beneficial ownership in that entity. In other words, if it is a company or an Inc., incorporated or company, who are the shareholders? If it's an LLC, who are the members? And we actually have to have their operating agreement. And I can't tell you how many times we're closing a deal with an LLC. I don't have an operating agreement. You're gonna need one. Okay, what does the operating agreement do? It says who the members are on it, and we see more LLCs. Okay, you can form an LLC this afternoon in about 10 minutes by picking up the phone and calling the Secretary of State and our company in Austin that does that. But there are more steps to do. Filing with the Secretary of State doesn't do it. You need an operating agreement that tells everybody else who owns this company, who has the managing authority, who can sign for this entity. Okay, not limited partners, the owners in the LLC, and I think it's beneficial ownership of 25% or more. Why? And we need address, phone number, identifying information. So we're not being ugly when we're asking, and we may ask for your help. We have to have it because the burden's on us. We don't have the information. Where do we get it? From the person. So that's coming. When this first hit, there were areas called GTOs that were target areas. And it was New York, Atlanta, Dallas, Houston, LA. And we could not, when we'd ask for the information, we couldn't say why we wanted it. Well, that was stupid. I mean, hey, I need this. Why? And we couldn't tell them why. It's so secret. Well, now FinCEN applies nationwide. And yeah, we'll tell them, but we have to have that information. So,
And at the end of the day, when they sell that property, they will have to provide that for the sale. So we're kind of helping them on the front end
right.
to say, get this in order. So when you go to sell, there's no way you're selling without these documents.
Correct. Okay. Y'all have been great to give me extra 30 minutes. Tina, I can't thank you enough. I will let you know the rest of my schedule. So we can get back to you. And this has been wonderful.
We appreciate
Thank you so much. Thank you, Mr. Turner, Megan, Tracy, long-term friends, and I forgot to mention Tracy has been friends for so long, and we're neighbors for so long. I want to thank you. Yes, this was wonderful. And I can see a lot of people have a lot of questions. Unfortunately, some of them had to leave early because we're literally scheduled this 1 hour just for production. It's not enough. It's so important. You know, earlier, Mr. Turner and Tina both said, oh, fill out this blank here is so important. Every blank in that form is so important. Everything is so important. So we're going to have to go through. That's why I go back to 124 Family over and over again. At least I maintain 4 trainings a year. Once I required to do that because it's so important. It's never enough.
No.
So thank you so much for coming here.
Yeah.
And I actually bought some Chick-fil-A nuggets and fries. So
smell
please
it.
have some. Sorry, it gets a little cold right now, but enjoy it. And I want to let you know that we do production training twice a month. It used to be a Wednesday, but this is the last Wednesday.
So just wait, check out the new calendar when we roll it out.
Okay.
We're finalizing the day and time and.
Yes, I want to talk to you too.
Okay, we'll finalize that and we'll let you know. All right, thank you.
Perfect.
Sure.